hearing in the matter of National Commercial Bank Jamaica Ltd and NCB Staff Association.
Yes. Yes.
Please, Madams. I'm Sandra Minor Phillips, and with me is Noel Levy. We are instructed by Myers, Fletcher and Gordon for the appellant. My learned friends, M. Georgia Gibson Henley in King's Counsel, Patricia Roberts Brown, and Jonathan Nita are instructed by Simons Muirhead Burton for the respondent.
Thank you.
My lords, I wish to start with a few opening sentences, if I may. A member of a group, and I use the word member in the wide sense to include staff, can only share in profits belonging to that group. He cannot share in profits that belong to someone else, that is, outsiders. That is why elimination of minority interest is integral to, inherent in, fundamental to the concept of consolidated profits of the group, no matter what accounting standard is used. This case, my lords, is about whether, for the year ended 30 September 2002, a share of the profits attributable to the bank was payable to its staff under the formula set out in the parties' contract for triggering the payment. The relevant formula, my lords, is set out in Clause 2 of the staff circular that you will see on page 287 of the record.
Okay.
And it's short, and since it turns on this interpretation, will you permit me to just read Clause 2? Let's. Clause 2 says, the maximum amount to be distributed shall be 6% of the consolidated profits before tax as agreed by the auditors before making allowance for the payments under the scheme, provided such profit is in excess of 25% of shareholders' funds. That is, issued share capital, reserves, excluding capital reserves, and retained earnings, as shown in the audited accounts of the immediately preceding financial year. Now, I won't read it, my lords, but I would ask you to take note of Clause 3 that is immediately below, because it calls the bank's auditors to action. And so it shows that the auditors are just integral to the process. Essentially, my lords, the Staff Association's case, which is evident from the fixed date claim form, which you find at pages 13 to 15 of the record, was about what obtained and transpired in the year ended 30 September 2002. And if you would permit me, my lords, I'll just synopsize the Staff Association's claim. The main declarations that the Staff Association sought were that NCB, I use NCB for the bank, the appellant, could not unilaterally amend the formula or unilaterally deduct minority interest profit. And so those declarations are the ones at item 2 and 3 on page 13. Also sought a declaration, which is at item 4. And I should say that those two declarations, that 2 and 3, those declarations were granted by the judge at first instance. They also sought the declaration at item 4 on page 14, which is that the deduction of the sum attributed to minority interest affirmed by PricewaterhouseCoopers was incorrect, as it was not in accordance with the proper interpretation of the circular. That declaration was not granted by the court at first instance.
Sorry, where were you reading from there?
Paragraph 4 of the...
Paragraph 4 on page 14, my lady.
The declaration that they erred in deducting minority interest profits.
Yes.
Right.
That declaration,
Paraphrasing it, fine.
yes, was not granted by the court of first instance. They also sought a declaration at paragraph 6 on page 14 that PricewaterhouseCoopers is to interpret the profit share formula as set out and not as it deems fit, and ought to have calculated the profit share for the year ended 30 September 2002 in accordance with the stipulated formula Pricewaterhouse used for the previous 16 years. That declaration was not granted by the court of first instance. They also sought at item 7 a declaration that for the financial year ended 30 September 2002, PricewaterhouseCoopers erred in making a special calculation of group profit.
Circulation.
Yes, well, I'm glad you brought that to my attention. It really is a misprint for, I believe it to be, although I was not in the case at either level below.
No, well, I did wonder.
Yes.
I mean, it's referred to, I think, in the judgment as a circulation.
Yes, I think
It can't be.
it can't be because there was no special circulation. So, and I think it echoes the word calculation in 6 above, my lord. You see where it says third line in 6 above, ought to have calculated?
Yes.
I think it's meant to capture. So I think circulation is really some clerical error along the way, and it gets repeated throughout. So I'd ask you to...
It finds its way into the judgments because
finds
they
its
quote
way,
the declaration.
and the declarations and everything, yes.
But I can't imagine
Yes.
that will create difficulty.
Yes, my
It
lord.
seems, no, I'm getting an indication that there isn't disagreement
Okay.
on that point.
Okay, great. So 7, the Staff Association sought a declaration for the financial year ended 30 September 2002 that Pricewaterhouse erred in making a special calculation of group profit before tax for the purpose of dealing with the profit share scheme. This declaration was granted by the Court of First Instance, and it is a primary subject of the bank's appeal to this court today. The Staff Association also sought at paragraph 8 a declaration that for the financial year ended 30 September 2002, the threshold for profit share had been triggered and the members of the Staff Association were entitled to a share of the profits to be calculated on the basis of the formula in clause 2 of the circular. That declaration was granted, and that is also the subject of, the primary subject of NCB's appeal. As
I understand it, what they get actually is not a share of the profits as such, but an extra month's salary. Is that how?
Well, the formula provided for a maximum of up to 6%, yes. And there was an agreement that there was a minimum of, that the minimum would be 1 month's salary. So there was a range of possibilities, my lady.
Where do we, sorry, I apologize. Where do I find the defense served on behalf of the bank?
Well, the matter was brought, I'm glad you asked that, yes. Because the matter was brought by way of fixed rate claim form, so there were no particulars of claims. It was supported by affidavits. Right. And so the defense essentially is reposed in the affidavits in response. And I will get to that. I will get to the bank's defense in short order, my lord. It is a submission of the bank, my lords, that the words consolidated profits before tax used in the formula was not a line item in any of the financial statements. That amount had to be worked out by the bank and verified or agreed by its auditors, PricewaterhouseCoopers. The descriptor does not appear in the financial statements for the year ended 30 September 2002. The evidence was that integral in the consolidation process is the elimination of minority interests.
Well, yes, I mean, as I understand it, your case remains that the phrase consolidated profits before taxation is a term of art in this particular agreement.
Yes, my lord.
Whatever the accounting standards may say.
Whatever is the applicable accounting standard. And I think the whole accounting standard argument took the court down a rabbit hole that it didn't need to go into, because whatever accounting standard was applicable.
Yes, I mean, do we have the accounting standard in the papers?
No, I don't think so, my lord.
So we only have indirect evidence as to what the accounting standard was.
Yes, but in the end, I don't think it matters, because the overall evidence from all the accountants in the case was that whichever standard applied, the elimination of minority interest was inherent in arriving at.
Well, I'm not sure if that was Mr. Christie's evidence.
Well, let me say, Mr. Sadler, Mr. Jane from PricewaterhouseCoopers, Mr. Raymond Campbell from KPMG were all added on that.
Because just test this. You say integral in the consolidation process is the deduction of minority interests, but the consolidation process, when you speak of consolidated accounts, from the top line downwards, there is a process of consolidation, is there not? That you are declaring the total income earned by the group.
Yes, madam.
Yes. So all consolidated means is that you are looking at all the companies within the group.
Yes, madam.
Yes. So it's not implicit in the word consolidation that one necessarily takes account of minority interests at that level. You quote everything consolidated right the way down to a figure which is, I won't use the word consolidated, the group profit before tax. That's right, isn't it?
Yes, my lord.
And that is consistent with the accountancy standard.
Yes, my lord.
And then you deduct tax, and then you deduct minority interests,
yes, my lord,
in order to achieve what you rightly say is the balance between what the shareholders' interest is on the one hand, the shareholders of the parent company,
yeah,
and on the other, the entitlement of the staff,
yes,
to a share.
Yes, madam.
Yes.
So are you going to be taking us to the 2002 account?
I am going to do that, my lady. But before I do that,
yes.
I just want to make
sure.
Yes, I am going to. I just want to say that consolidated profit before tax, following on from what my Lord President has said, the consolidated profit before tax of the group would comprise the profits or loss of the bank, as A, what I call A. B, the bank's share of the profit or loss of associated companies, that is, companies in which the bank owns 50% or less of the shares. C, the profit or loss of wholly owned subsidiaries of the bank. And D, if there are subsidiaries with minority holdings, the profits of those subsidiaries less the profit attributable to the minority interest.
But there is no such line in any official accounts. This is something you say which has to be worked out.
To be worked out.
Yes.
I'm going to take you now, my lady, to...
But so I mean, it is absolutely critical to your case, as I understand it, that consolidated profits before tax on this contract is a term of art, which is not to be found in the statutory accounts of the particular group. Is that right?
Yes, my lord.
Yeah.
So, moving straight away to the financial statements for the year ended 30 September 2002, if you look at page 459,
Just could you remind me, please, that there are no earlier accounts at all? Is that right?
There are parts of earlier accounts throughout. So, for instance, if you look at 776, 778, 777, for instance, you see financial statements for the year ended September 1992. For instance, just by way of an example, my lord.
This is page
776.
776, thank you so much. Just let me bring it up.
And one of the reasons why this page even stuck in my mind is because I thought it usefully illustrated how it is that the bank dealt with associated companies as different from subsidiaries in which it had a minority interest.
Well, I thought you said associated companies were the ones in which had a minority interest.
Right, the other way around. Yes, thank you, my lady. And this shows it clearly, because if you look at 776, you see halfway down the page, associated companies are as follows: Caribbean Home Insurance Company, Inn on the Beach, Siboney Hotel Developers.
Sorry, this is
776, my lord, you had said that you had gone to 776.
I've got 776, and what are you reading from that?
I'm reading halfway down the page. I'm just showing how associated companies are defined there. You see, halfway down the page, you see associated companies, you see Caribbean Home, Inn on the Beach, Siboney Hotel. You see those, my lords?
No, the 776 is simply the profit and loss account, and we have a heading, profit before taxation and extraordinary
And
items.
above that, we have the share of results of associated companies, which is about $6.6 million.
Yeah.
But I can't see the companies' names that you're...
Is it page 775?
My lords, I'm totally at sea now, because you're not seeing a document.
775.
775, we've got a list of companies.
Yes.
Yes.
Is there a page difference between your numbering and mine?
I see. So
You were seeing consolidated balance sheet on 776. If you turn the page, you see notes to financial statements.
Yes.
Would it be on 777 then, of your lordship's own?
Well, the page where you were listing the associated companies, Caribbean Home, NCB Insurance, etc., is 775 in the electronic bundle.
So there seems to be a page out for some reason. Yes. I'm sorry about that, madam.
No, it's not your fault. So we see there that as at 1992.
Okay. My friend is saying it's one page out. Yes.
Yes.
So I'm sorry about that.
We see that as at 1992, the bank had two companies in which they had a substantial majority stake. And then
yes.
They had three companies where they had 50% or...
Yes, my lords. And that's why I thought this particular one stuck in my mind, because it was useful. Because in relation to the three where it has a minority interest, which I refer to as associated companies, if you look down at note C below, you will see that in relation to associated companies, they are accounted for by the equity method. By this method, the group share of profit is included in the group profit and loss account. So if you look at the next page over, you will see that in relation to halfway down on the operating profit, you see share of results of associated companies, 6,637,000.
So,
And that's just the bank's share of the associated companies.
Right.
That figure is just the bank's share.
Yes,
what
but
you're
sorry.
So what you're saying is that we can assume that that $6.6 million is the aggregate of 47.5% of Caribbean Home NCB insurance company's profits, plus 50% of In on the Beach development, plus 20% of Siboney Hotel.
Yes, my lady. And so that's in relation to those companies where the bank had a minority interest. So it is only the bank's interest in those companies that comes into the consolidated profit and loss account.
Yes.
Whereas if you look at the two above now, which is the NCB Insurance and Jamaica Orange Company, which is the 74% and the 65%. Are your lordships with me?
Yes.
Yeah.
And why is there a difference between those companies?
Because those companies now are treated, the entire amount of the results of those companies is brought into the profit and loss account, and you see that item at 476,135,000, and then right under it you see an item called 9,580,000, and that 9,580,000 is the minority interest, which is then deducted from the overall figure to arrive at 466,555, which is the group's interest less the minority interest taken out.
And what is the reason why a majority interest is dealt with in a separate... Differently.
I'm just a lawyer,
Well, presumably it's because, it may be because the company controls those subsidiaries and it doesn't control the others.
It doesn't. So it only, yes, that would be a logical explanation, my lady. But the fact is they are dealt with differently. And so in the four items that I gave you before I segued into that example, when I was speaking about what the bank's profit comprises, I had said profit and loss of the bank's share of the profit and loss of associated companies, the profit and loss of the wholly owned subsidiaries of the bank. That doesn't present any problem because they're wholly owned. And and in relation to those subsidiaries with minority holdings, the profits of those subsidiaries less the profits attributable to the minority interest.
What would happen then if you go back to page 775 and the interest of NCB in an associated company was 50.5%? Would that company then be a subsidiary?
Yes.
As the same as NCB Insurance Services and Jamaica Orange Company Limited?
Yes, my lord. It would be, and I'll take you to that in the 2000. I'll show you that in the 2002 accounts. Right. But in relation to those four categories that I just outlined for you, my lords, B and D.
Sorry?
In those two, I just showed you four categories that comprise the bank's
But you said B and D, did you?
Sorry, I had said A was the profit and loss of the bank. B was the bank's share of the profit of associated companies. C was the profit of or loss of wholly owned subsidiaries of the bank. And D was if there are subsidiaries with minority holdings, the profits of those subsidiaries less the profits attributable to the minority holdings. And I was going on to further say that in relation to B and D, the minority interest, or in relation to B and D, there is an interest that does not form a part of the bank's consolidated profit. And as I was able to illustrate by taking you to the document on 776, in the case of associated companies where the bank owns less than 50%, it is only the bank's interest that comes to the consolidated profit and loss. And in the case of subsidiaries with a minority holding, it is a whole profit that is brought into the profit and loss account, and then the minority interest is excised from the figure.
But is the taxation figure, where does that come from? Is it just assumed to be across-the-board percentage, or is there a specific calculation of taxation? I'm asking that to work out how difficult arithmetically it is to do the exercise that you say needs to be done, which is to effectively deduct the minority interest in results of subsidiaries from the pre-tax profit before taxation and extraordinary item line. I think that's what your case is that you have to do. You have to do that deduction that's done here after tax, before tax. But I'm wondering how difficult that is, whether it's just, okay, so minority interest, what proportion of 476,135 is 9580, however much that is, so then you just deduct that same proportion from 671,096.
Well, that is one of the reasons, my lady, why the accountants need to verify the figures. And then there was
But please answer the question.
Yes. So
what is the taxation figure in the account? I think it refers to note 3, doesn't it? Do we have note 3?
I don't know that one. Note 3 on 776.
I'm just wondering whether taxation is a straight line or whether it's not a straight line.
Well, I don't know if I'm not sure if I'm understanding or going to be answering your question correctly, but there is evidence from the accountants which showed that, and I don't know if this addresses it, but there was that whether the calculation taxation is whether it's done before or after is a matter of convenience for the auditors, because it didn't make sense for them to go through item by item and then do the taxation as they went along. So for a matter of convenience, it was probably done after. But if I'm understanding or remembering the evidence correctly, but it didn't really add or subtract anything to the process that was involved.
Well, it only for this reason, that what you're saying is that you cannot, I understand your case to be, that you cannot just look at a line in these accounts or in the equivalent 2002 accounts and say, that is the consolidated profit before taxation. You say that the judge was wrong in saying that that's actually a line in the accounts, that you say that there's a sum that needs to be done to add back in the tax and then deduct the minority interest to get
what you're trying to get at is the consolidated profit before tax attributable to the shareholders of the NCB.
Exactly, right. What I'm trying to explore is how clear or opaque is that figure from this. It could be very simple. You could, as I say, just say, well, arithmetically, as I say, you work out what proportion of 476,135 comprises 9580, and then just multiply the profit before tax and extraordinary items by that, and that would get it. But that depends on what that taxation figure is, if it's just a straight 20% across everything or not.
Yes, my lady, I think that it may be helpful when I get to it, which I will do very shortly, to show how Pricewaterhouse actually did the calculation.
Yes, but we're wanting to explore also, I think we have to understand how it's presented in the accounts, because I understand if we're looking at page 776, if you start at the top, the revenue figure is the consolidated revenue figure, is that right? And the expenses are the consolidated expenses, which would include the expenses of all the subsidiaries, either 100% owned or majority owned.
When you say consolidated, I think though you mean, let's not use that word, you mean the total.
Yes.
So
but these are, it's a consolidated profit and loss account. That is what it's called.
Yes.
And it's the total revenue for the group. It's the total expenses for the group, giving rise to an operating profit. At that point, you add back in simply the share of the results, which is the profit in the minority companies where there isn't control, and come up with a figure of, let's use a neutral term, of group profit before taxation. That is how it's presented.
Yes, my lord.
And that is, and all that is in accordance, as I understand the evidence, with the relevant guidance at the time in the Jamaican GAAP.
Well, I hear you, my lord, but I understood the evidence to be saying that the process that was required, it didn't matter whether it was GAAP or IAS or I.
Well, that's based on the argument that there is a term of art used here rather than looking to a line in the consolidated accounts to find out what is the group profit before taxation. That is the real battleground.
Yeah. So I think what my lord is asking is the revenue figures and the expenses figures, that they include the total revenue and total expenses of all the subsidiaries, rather than just the appropriate proportion of those. Do we know?
The subsidiaries, but not the associated companies.
That's what they are.
The answer, I think, is yes, of the subsidiaries, but not the
It includes all the total revenue and total expenses of all the subsidiaries.
subsidiaries, but
Not the associated companies.
So, my lads, if you look, if I could go to 2002.
So I do apologise, but there's a document at page 333 which deals with profits before tax. It deals with the concept of consolidated profit and tax. I was wondering whether that
What page is that?
333 throws any light on how one deals with tax.
I can't say, my lord, that was the document that immediately preceded the parties' agreement on the 17th of December. So I confess to have focused on the parties' agreement on the 17th of December.
And just to confirm, we don't have the accounts for this year. They have a profit before tax and before profit sharing of 9,892,456. It would be great if we actually had those accounts, but one doesn't. Is that right?
I don't think so, my lord.
Okay. Sorry, I apologise. I diverted you. Okay.
So, my lords, if we could go to, first of all, page 459. I hope it's 459 on your, I'm looking at the notes to the financial statements for the year ended 30 September 2002. It would either be 459 or 460 of your electronic bundle, I'm not sure which.
Well, this is the notes to financial statements.
For the year ended, the subject year, which is 30 September 2002.
With the list of the companies.
Yes, my lads. And just to show you that the bank subsidiaries, as at the 30th of September 2002, the bank was 100% owned. But if you look in the line just below the grid, you will see effective 7 August 2002, the bank acquired the remaining 49.5% of the ordinary shares in Edward Gale and Company Limited. So that, my lads, up to 7 August 2002, there was a minority interest in Edward Gale and Company Limited.
And were there any associated companies or not?
No, by that time, no. So if you look at 449, my lads, which is the consolidated profit and loss account for the year ending 30 September 2002.
449.
Do your lordships have that at 449 or 500 if there's a page difference?
No, it's 449.
449. These now are the audited accounts, because there might be another set, but this set starting at page 448, at 444, sorry. This is the audited accounts. And if you look at 449, my lords, you will see an item called profit before taxation and ordinary items. About quarter way down the page.
Profit before exceptional items and taxation, is that what you're looking at?
No, it's below that.
Profit before taxation and extraordinary items.
Yes, I see that.
And the figure is $2,209,286. And then if you go right below that, you'll see taxation is taken out, 186 million, resulting in another figure of 2,023,285. And then you see below that the item, minority interest in result of subsidiaries, 63,121. 63,121,000.
Yes.
That figure represents the minority interest in Edward Gale and Company Limited that did not form a part of the return to the shareholders of the NCB group. And
that is on your interpretation of consolidated profits before tax being a term of art rather than being a description of the line above profit before exceptional items and taxation.
Yes, my lord. And so you see, after the elimination of that 63 million, you come to 1,960,000,000, etc. Now, if you I don't know if you can, have that page available to you still while looking at the page at page 316, which is a page that sets out how the calculation was done by PricewaterhouseCoopers. Now you will recall, my lord, that the formula under clause 2 required finding 25% of the shareholders' funds. So if you look at page 316, you will see in the grid on the left-hand page. Do you have a grid on your left-hand page on 316, my lords? I should say that this document is a communique dated the 23rd of December 2002 from the bank to its members, setting out why the auditors the auditor's recommendation and why no profit share was triggered for the year ending 30 September 2002. This is a document that communicates that. And it's important documents. If you would permit me, just above the grid, it says, the computation as produced by the external auditors following the established computation formula is as follows. Shareholders' funds as at September 30, 2001, 9 billion, less capital reserves of 278 million. Pausing there for the moment. If you look at page 451 at the consolidated balance sheet, and you go to the year 2001, because remember now you're using a computation from the previous years, the immediately preceding years figures. I hope on page 451 you have the consolidated balance sheet.
Yes.
Right. And if you look to the extreme right, you see the figures for the year 2001 in that column. And if you go down to just above the total at the end, you say 9 billion 065 million 199.
Yes.
And that is the exact figure that you have on page 316, representing shareholders' funds as at September 30, 2001. 9 billion 065 199. That's where that figure comes from. And then, if you look above, if you look at 451, you're still on the balance sheet, and you go like 4 items up, you will see the capital reserve of 278,462. Your Lordship see that? And if you look at page 316, you will see less capital reserves of 278,462. That's that figure there that comes from the financial statements. And then there is a total of 8,786 million. And so, in applying the formula, they're finding what is 25% of that figure. And 25% of that figure is 2,196,684. And I'm on page 316. Are your Lordships with me?
So we take the shareholders' funds less capital reserves.
Yes.
Get the total.
You get the total.
25%.
And then you take 25% of that. This is now applying the formula, which requires, remember the formula requires you to take 25%. So you take 25% of that, and you get 2,196,000,000. And that is the trigger. That is the sum that represents the trigger or whether a profit share is triggered or not. And then below, still on page 316, if your Lordships are with me.
Yes.
You see the consolidated, the profit before taxation, September 30, 2002, of 2,209,286.
But do note the name given to that figure, consolidated profit before taxation, and then go to page 451. I think it was it 449, I think it is.
449.
449.
Yes.
And the
word consolidated is not there on 449.
no, but the figure is before taxation and before minority interests.
Yes.
So it does seem to suggest that everybody knew what consolidated profits before taxation meant, and it meant the figure before taxation and before the withdrawal of the minority interest.
Well,
That's how it's presented to. That's how the bank is presenting that figure to the to its members.
But I see they don't do, they make it simple. They don't add back in any tax to the 63121, which you would say, well, that favours the staff association, because if you added back the tax, it would be more than 63121, which so you would deduct more, so that would then make it a lower figure and therefore less likely to be more than 25% of the shareholders' funds less capital reserves.
We don't know who's paid the tax, I don't think, from this presentation.
But they're deducting a post-tax figure from a pre-tax figure, which is not quite right, but as I say, it favours the staff association to do it like that.
It may, if the tax is paid by the owners of the minority interests rather than
they don't do an arithmetical recalculation of the pre-tax profit.
So, my lads, still on 316, if I may, just to show how PricewaterhouseCoopers worked it out. They then deduct the profit attributable to minority interest of 63,121,000, which I had already showed you on page 449, which is the minority interest in Edward Gale and Company. That has no place in NCB's profits. They deduct that, and they get the sum of 2,146,000,000. And at the top of 317, you see that they say, based on this computation, there's a shortfall of 50.5 million from the required return of 25% of relevant shareholders' funds. External auditors provided the board with this opinion. Profit sharing is payable at a maximum of 6% of consolidated profit before tax, where such profit is in excess of the issued share capital and reserves, excluding capital reserves of National Commercial Bank Jamaica Ltd, as shown in the audited financial statements of the immediate preceding year. Therefore, no profit share is payable. And this is a quote.
But do we have any previous years' equivalent memorandum? I don't think we do.
I don't think we do, my lady.
And in the subsequent years, equivalent memorandum?
I don't think so, my lady.
But in subsequent years, there would just be 100% subsidiaries, unless...
Yes, there would be no minority interest in subsequent years.
Yes, I mean, do we know from the evidence whether there were subsidiaries with minority interests in 1980?
I can check on that and get back to you.
Yes.
But
because if there weren't, this problem wouldn't arise back in 1980. All you do is just go to the line consolidated profits before tax in the accounts, however it's called.
What we do know from PricewaterhouseCoopers is that in all the 22 or so years that they had been doing this, they had been doing it the same way. They never changed.
Well, you'll have to show me the evidence to that effect, because I thought the evidence was they didn't have the papers.
They didn't have the papers to show their workings for the year, but they said that...
Anyway, refer me to the evidence that vouches that proposition. You don't have to do it just now, please.
Oh, okay.
But if you're learned junior, could dig it up.
Yes, we will do that. And I think it's footnoted in our written case as well, but when we get there. So, my lords, it is not in dispute. It is not in dispute that the calculation of consolidated profits of NCB before tax, as affirmed by the auditors, let me start that again. It is not in dispute that in the calculation of consolidated profits of NCB before tax, as affirmed by the auditors, the minority interest in subsidiaries was excluded, but for that exclusion, the required threshold for triggering the profit share to staff would have been reached. That is not in dispute.
I think there is no dispute, I'll just check about the arithmetic. Namely, if you take out the minority interests of Abigail, then the entitlement's not triggered.
Yes.
If you leave them in, then it is. I think that's the battleground. That's the background to the battle.
Yes,
and the question is, does consolidated profit before taxation, and what has been held to be this contract, allow for the deduction of minority interest?
Yes, was a deduction of minority interest called for.
Yeah.
So the calculation was done in accordance with the formula. This is from the bank's, the bank's case is that the calculation was done in accordance with the formula set out in clause 2. And that the deduction of minority interest was not a unilateral act of NCB or of PricewaterhouseCoopers. There is evidential material from the Staff Association from 2 years before, that is in 2002, that they knew that under the formula, the profit share was payable once the level of profit exceeds 25% return on shareholders' funds due to all shareholders of the NCB group. And that is a sentence extracted from a letter which starts on page 510 and ends on page 514. A letter dated 27 November 2000. And this is a letter written by the Staff Association. And on page 514, which is page 5 of the letter, you see the second paragraph from the top. It says, under these arrangements, profit sharing is triggered once the NCB group's consolidated profit exceeds 25% of the shareholders' funds of the NCB group, as reflected in the audited accounts of the immediate preceding year. That is to say, profit sharing is payable once the level of profit exceeds 25% on the shareholders' funds due to all the shareholders of the NCB group. Doesn't include outside shareholders.
But how is this letter relevant to the interpretation of the contract? I mean, this is a letter written after the event.
No, this is before the event, my lord.
For which event?
This is 2000, my lord.
Yes, but is it your initial defence, the bank's initial defence was there wasn't a contract, it was a discretion.
Yes, but
that was rejected.
Yes.
At some stage, the contract came into being. When did you understand the contract to come into being?
I think the bank conceded that it was a contractual term from it came in 1980.
Well, how can a letter in 2002 be relevant to interpreting the contract in 1980?
No. I think it was, I was using it to assist in showing their understanding of what obtained, and that what they understood is what was done in 2002. So I wasn't really relating it back to...
Well, I mean, the nub of this appeal is simply, can be simply stated, was consolidated profits before tax a term of art in this particular contract, or was it to be understood as a line that could be ascertained from the company's accounts, not only by the company, but by its members?
That's where the battle is joined, my lord. That is absolutely where the battle is joined.
And in that case, how does a statement in 2002 assist us interpreting the contract?
Well, my lord, I was placing emphasis on the last words, that the return is to the funds due to the shareholders of the NCB group, as indicating that it would not include outsider shareholders. So that is all I was, that's all I was using it for. My lords, NCB submits that it would follow from clause 2 being a contractual term that not only the bank, but the staff association as well was bound by the opinion of the bank's auditors as to whether the profit share was triggered in applying the formula. That opinion derived from the figures as audited set out in the bank's consolidated profit and loss account for 2002 and the consolidated balance sheet for 2001. So in taking a decision that reflected the agreement of its auditors, PricewaterhouseCoopers, as set out in their opinion, the bank was adhering to the terms of the profit share scheme, not unilaterally amending it. The request made of the court by the Staff Association to declare that PricewaterhouseCoopers had erred in deducting minority interest from profits before tax, and that in doing so it was acting contrary to the formula, was refused. The court didn't grant that declaration.
That was declaration number?
Was it 4?
I think it is.
Yeah, I think it was 4, my lord.
I think so, thank you.
So too refused was the request of the court to declare that PricewaterhouseCoopers interpreted the profit share formula as set out in clause 2 and not as it saw fit regarding the year ended 30 September 2002. And that was declaration number 6.
Yes, thank you.
Given the evidence before the court, NCB states those declarations could not have been granted even if PricewaterhouseCoopers had been a party to the action, which it was not. And I say that because if you have read when you read my written case, I'm sure you have read it already.
Well, yes, we have read it.
I'm sure you have read it already. You will see that I say, in fairness to the judge, I do point out that he did say, when I was dealing with the inconsistencies between the declarations granted and the declarations refused, I did want to say that in fairness to the judge, there is in the transcript a statement by him that he didn't make the declarations because PricewaterhouseCoopers was not before him as a party. But yet and for all, he went on to still make a declaration against PricewaterhouseCoopers, which raises a question as to whether that was truly the reason or whether, as we say, he couldn't have made a declaration on the evidence that was before him. NCB submits, my lords, that the court was wrong in granting a declaration that for the financial year ended September 30, 2002, Pricewaterhouse erred in making a special calculation of group profit before tax. And we say that is so because...
And that special calculation is the one you showed us in that grid, then, presumably?
Yes.
What's special about it is the deduction of the Edward Gale.
Yeah, that is yes. And we're not saying it was special. I mean, that's a term that they use in their claim, because Pricewaterhouse evidence, which I'll get to, is that it didn't do anything any differently from as it had done for all the years before.
Well, again, I want evidence on that point.
Yes, I'm going to come to that one.
Because I thought it was left, it was rather left in the air as to what had happened before. I need evidence and also a finding of fact by the judge to that effect, because we're dealing with his findings.
of a finding of fact that Pricewaterhouse didn't do anything differently from the year before.
Because we can't just sort of dip into the evidence here and there. I mean, ultimately, unless a challenge is made to a finding of fact on the basis that there was no evidence to support it, then we are accepting the findings of fact. But this isn't a case of concurrent findings of fact excluding the appeal.
My Lord, I'll come to it. I'll come to it. Just make a note. And the reason we say that, my lords, is because the excision of minority interest is inherent in arriving at NCB's consolidated profit before tax. PwC was right to do the special calculation for the purpose of ascertaining whether the profit share was triggered. And I think that the way that declaration is worded, the way that request for that declaration was worded about it being a special calculation derives from, I think, the evidence of Christie that it was a line item, so you didn't need to do a special calculation. So
yes, the word, in fact, is in the declaration, isn't it?
Well, remember, the declaration used the word special circulation. But
yes.
Yes, yeah? But I think...
Right, because Mr. Christie's case was that what they should do is just take profit before exceptional items and taxation.
Yeah.
And not make any deduction from that.
So it follows from the bank's understanding that NCB also maintains that the declaration that profit share had been triggered for the year ended 2002 was also wrong. There was an abundance of evidence that Pricewaterhouse did not err in deducting minority interest in subsidiary when applying the formula. It was in fact the view of the judge that there was agreement among the accountants. So it was not a controversial thing.
Which paragraph are you referring to in the judge's judgment?
It is in the transcript, my lord. It may not be in the judgment, but it is in the transcript.
Well, I mean, we can't just lift passages out of the transcript about what the judge said at a certain stage in the proceedings.
I think it is.
We are tied to his judgment.
Yes, my lord. I think it is footnoted in my written case, my lord. So when I get there, it will be easier for me to pick it out then, if you would. The evidence of NCB and the defense, which my lord asked me about earlier,
Yes.
was that if you look at page 228, paragraph 15,
This is Mr. Sadler's affidavit.
Yes, my lords. The bank accepted the independent and professional advice from PricewaterhouseCoopers that profit attributable to minority equity holdings in subsidiaries should not be included in the calculation of consolidated profits before tax.
We're reading from paragraph
15, my lords.
15,
I'm
sorry,
reading
I'm so
paragraph.
sorry. Yes, of course. It's 228.
For the purposes of determining whether a profit share was payable to the staff and the amount of such profit share. And of course, my lords, the 23 December 2002 communique that I had showed you before also was exhibited by the bank in support of its position. That is the one I had showed you at page 316. And then PricewaterhouseCoopers agrees specifically with that paragraph of the affidavit of Malcolm Sadler, and you will find that at page 1295 to 1296.
Page what, sorry?
1295 to 1296. At 1295, line 19, hopefully we're on the same page, you will see question. Now, if you're looking at page 182 and paragraph 15, that 182 is really 228 in your bundle. Are you where I am, my lads? You will see that the bank is saying, and you will see it says, the bank accepted the independent and professional advice from PwC that profit attributed to minority equity holdings in subsidiaries should not be included in the calculation of consolidated profit before tax for the purpose of determining whether profit share was payable to the staff and the amount of such profit share. So it's actually reciting paragraph 15 of Malcolm Sadler's affidavit. The bank is saying, you know, we get that information from Pricewaterhouse. You agree with that? That is what the bank is saying? Yes. And I stated that earlier. That is what I indicated I understood by, as agreed by the auditors when we read the clause. So the bank does the calculation under the formula, and the auditors are called upon to agree. And the bank is saying that it accepted Pricewaterhouse's advice, and the auditor, who is being cross-examined here, Pricewaterhouse auditor, is saying, I agree with what the bank says there. And then, interestingly, my lords, if you look at page 1297 to 1298, I just want to point out where the judge says, to the Council for the Staff Association.
What are we looking at in 1297?
1297, this is a judge. The judge now is commenting on the Staff Association's lawyer speaking about the bank and the auditors being in agreement, and the opinion given to the bank by the auditors. And his lordship in line 24 says, nobody's disputing that, Mr. Miller. That is not an issue. What is clear is that the bank acted on their advice, and that is how come it did not trigger the profit share. That's the judge saying that.
But what do we take from that?
That this was the bank's defense, because when you look at the judgment, my lords, you see that the bank's defense is presented by the court as being that the deduction of minority interest was made because there was a change in the accounting standards.
And you were saying that was not the case?
That was not the case.
No.
What about the passage, page 221, paragraph 30? It may be a bit of a red herring in one sense, because it's ultimately a matter for
Yes.
the proper construction of the contract.
Precisely.
But this is Mr. Cummings saying in 2002 the use of the international accounting standards became mandatory in Jamaica, and the
Yes.
manner of preparation of the audited financial statements changed.
Yes, yes,
But
yes. And
there was no change.
there was a change, but it was immaterial to the fact that minority interest was going to be deducted.
Well, I think it was also only applied prospectively, so I think that it was also, the evidence was that even if there had been, I think
it might not have applied.
that it didn't make any, the change in the accounting standards didn't make any difference as far as this question was concerned, and in any event, it only applied from accounts from 2003 onwards.
Yes.
Yeah.
And Mr. Cummings was in fact
But
human resources person, and I think his understanding may have been imperfect, which is what I point out at paragraph 36 of the Appellant's case.
yes, but your position is, as I understand it, other than what Mr. Cummings says here in paragraph 30 and following, your position is here that the bank was never saying that things changed in 2002.
The bank was never saying that because of an accounting standards change, that is what resulted in the deduction of the minority interest.
Because it was that led to some rather stark words by Mr. Justice Sykes about the bank's behaviour.
Yes, yes.
But you're saying it's a misunderstanding of the bank's defence?
Yes, I am.
Thank you.
And so between the actual document that the bank puts forward saying why it is they did not issue a trigger, which was the 23 December 2002 communique, the evidence from Malcolm Sadler in paragraph 15 that they followed the advice of their auditors, the evidence of the auditor that what Sadler was saying was correct, that is what they did, and the evidence of the judge saying in the transcript that it is clear that what the bank was doing was acting on the advice of the auditors, and that is how it did not
But the auditors still have to apply the formula as it's contractually agreed, isn't it?
Yes.
Yeah.
Yes, and they're saying they did so, my lady.
Yes,
Well, that's for us. But
that's for us. I mean,
No,
at the end
yes, I know, but I know it is a matter for you as to whether they were correct when they said so.
Yes.
Yes, I'm not trying to usurp.
Yes, but what you're saying is there was no bad faith on the part of the bank or on the part of the auditor. But in any event, I doubt the question of good faith and bad faith arises in this appeal at all.
Well, I think they have expressly withdrawn it.
It's been expressly withdrawn.
It has been expressly withdrawn.
Right, I've forgotten that. But the fundamental question comes back to what was agreed in 1980.
Yes.
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 And I mean, can you tell me, back in 1980, was there any evidence that the bank had subsidiaries with minority interests at that stage?
I can't tell you off the top of my head, my lord, but if you...
Because we know, I think, that Edward Gale was acquired in the early 90s, or at least the parent company of Edward Gale was acquired in the early 90s, thereby giving the bank a subsidiary in the form of Edward Gale, in which there were minority interests.
To try to pin it down, my lords, what the bank is saying is that the Staff Association mounted its case on 3 pillars. The first one was that the deduction of minority interest in determining consolidated profit before tax attributable to NCB was inconsistent with the agreed formula for determining whether a profit share was triggered. Before I do this, just generically, my lord, if I could address that question, because the formula in clause 2, I mean, without just on first principles, if the formula in clause 2 is speaking about consolidated profit before tax, I think it must follow that there were other members of the group, because they don't have consolidated unless there's a group.
Yes, but of that there is no doubt. But were there subsidiaries with minority interests? Was the problem which has emerged certainly
That I would have to check
by
further.
2002?
Yeah, but
Was there evidence?
Well,
there would have been a group as to the exact how it was comprised in 1980.
I think in the respondent's statement at paragraph 48, which is at page 1881, there is a reference to the trial judge finding that Edward Gale and Company was acquired in 1980. But I'm not sure where they get that from. Unchallenged.
This is in 1980.
Sorry.
If you look at page 511,
1881, paragraph 48.
1881?
Yes. Unchallenged evidence of the respondent's witness, Mr. Stewart, on the bank acquiring Edward Gale and Company in 1980. That's EB.
I think if you look at 511, it's probably more helpful, my lords.
511.
Edward Gale was acquired in 1994. It wasn't acquired in 1980. But if you look at 511, in that same letter from the staff association that I showed you earlier, where you were asking me about the relevance of the sentence to the 1980 agreement. If you look on a prior page, 511, you see the first payment under the scheme was made in 1980 December in respect of the profits for the following year. 1980 September 30. At that time, the group was comprised of the following companies: National Commercial Bank Parent Company, subsidiaries, National Commercial Mortgage and Trust, West Indies Trust, Corporation Limited, Noxid Limited and its subsidiary. I'm not seeing where there's a breakdown of...
Well, so is Edward Gale part of the Mutual Security Bank group of companies?
No.
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 Okay, well, there seems to be a difference of opinion.
But you see on the next page, Edward Gale is mentioned, but he's there talking about 2000. So that doesn't help you with 1980.
Yeah, but in any event, I don't think there have been findings about this at all by the judge. But you're not disputing the accuracy of the statement in this letter that back in 1980 there were these 4 subsidiaries.
No, I have no basis to dispute that.
But
as to the percentages,
you don't know.
As to the percentages, I'll try to see if there's something further that I can find in the record. So, my lords, I'm saying that the case for the staff association was mounted on 3 pillars. The first one was that the deduction of minority interest in determining consolidated profit before tax attributable to NCB was inconsistent with the agreed formula for determining whether a profit share was triggered. The second pillar was that in verifying the calculation made by the bank using the formula, PricewaterhouseCoopers acted inconsistently with how it had performed this function, this verification function over the past 16 years. The third pillar was that with the concurrence of PricewaterhouseCoopers, there was an alteration by NCB of the method used to calculate whether a profit share was triggered for the year ended 2002.
Could you remind me, pillar 1 was?
The deduction of minority interest in determining consolidated profit before tax attributable to NCB was inconsistent with the agreed formula for determining whether the profit share
So
was
this
triggered.
is the pillar of what then? The judges?
No, I'm saying this is how we understood the Staff Association had mounted its case on these three pillars.
But, I mean, unless Pillar 1 holds up, the others are irrelevant. I mean, if Pillar 1 holds up, then that will determine the whole case, will it?
Yes, absolutely. Absolutely, Madam. And we're saying the material before the courts supports the upholding of Pillar 1. All of the pillars, in fact, including Pillar 1. Sorry, not the upholding of it. The material before the court supports the fact that none of those pillars was established.
But the judge in his opening 2 paragraphs does seem to place a great deal of weight on his conclusion that the bank had put forward a false reason why it had made a change. So he was finding that there had been a change in 2002 and that a false reason had been put forward. But you, I think, say there was no evidence to support either.
No, my lady.
Do we know whether, in the hearing before, Mr. Justice Sykes, counsel for the bank, did in fact argue for the existence of that change, whatever the evidence that might have been?
The fact is their case was, the case that they put forward took so many different angles. It's hard to pin them down. I think that might very well have been one of their
So the council may well have raised this angle even if the evidence didn't support it at the end of the day.
Yes.
Yes, because it would be very strange if the judge had built a superstructure of a change in 2002 as the basis of one of the bank's defences, if the bank hadn't advanced it. But, I mean, do we have the transcript of the submissions to the judge?
The transcript, yes. Well, not the submissions, not the closing submissions, just the evidence.
So we don't know.
We don't have that.
I mean,
No.
clearly, the case is narrowed from what it was originally, because the bank's big defence at the start was there was no contract at all.
Yes.
And, you know,
Well, that was one element of their defense, but they abandoned that
well, they abandoned it in the Court of Appeal.
in the Court of Appeal. Yes.
So all the transcripts that we have in the bundle are the transcripts of the evidence.
Yes, my lady. So touching, if I might, my lady, on your noticing of how the judge presented the bank's defense at first instance. I would want to say that the presentation by the court of first instance of the change in accounting standards as the sole reason for NCB's deduction of minority interest in subsidiaries is a complete distortion of the bank's case and of the evidence before the court.
But how can you say that if you accept that the bank may well have argued through their counsel that there was a change in 2002?
No, the bank, that is not what I'm, if I said that, that's not what I meant to say.
Well, I understood you saying that they advanced many arguments.
No, I thought you meant I thought you were speaking about the Staff Association.
No, I asked
We
you.
were at cross
I asked you whether counsel advanced, for the bank, advanced a case in submission to the effect that there had been a change in 2002.
A change of how the formula was applied? No, my lord.
No. Whether there was a change in the accounting rules which required the bank to adopt the position it took. That's what the judge seems to think in paragraph 2, what was being argued by the bank.
Oh yes. There was, and it is not until the Court of Appeal judgment that you see that counsel for the bank says that I think he says he's no longer dealing with a change in the accounting.
Well, to my mind, that suggested that counsel had argued.
Yes, my lord. So we were at it then, actually. I did understand you correctly. But I'm saying, what I am saying, my lords, and what I wish to be understood to be saying, is that what you need to look at is what was the bank's defense. The bank's defense on the documents, on the affidavit evidence, and on the evidence of its witnesses was that the deduction of the minority interest was something that was necessitated by a proper interpretation of the formula in clause 2, and that had been done not only in the year 2002. That interpretation had been brought to bear by Pricewaterhouse not only in 2002 but in the entire 16 years.
Whereabouts do they say that? Which affidavit do we turn up to see PricewaterhouseCoopers saying that that's not only the interpretation we applied in 2002, it's the interpretation we've applied?
Well, I've asked this question already, and it's one to which the board would like an answer.
Yes, Mothers. EF page 1325.
So 13. I'm terribly sorry, I didn't get the page number.
If we can start 1215.
1215.
I refer you to paragraph 49 of the bank's written submissions on EF page 1847, which is at
yes, this is important.
tab 3 of the key documents bundle.
So 1215, what do we see in 1215? Let's just take this slowly.
Yes.
Now, whose evidence are we looking at here?
I think Mr. James. Is this Mr. James' evidence?
I assume so.
Whereabouts on 1215 does PricewaterhouseCoopers say this is the interpretation we have consistently applied?
Well, I'm starting at 1215. I'm getting to that, which is at page 1325.
Let's start with 1215.
That's 1325.
What he says is he doesn't have access to the computation to the working
excuse me, I'm having difficulty concentrating because of the noise that's coming. If you could keep the sound down.
I'm sorry. 1215, I don't have access to any of the computation, even for 2002, the working papers they don't retain. So I can't say definitively how the computations were done and specifically how the minority interest line was treated with. But he can say, as a matter of principle, he treats it as fundamental.
The elimination of minority interest is fundamental to the concept of consolidation, and that existed prior to 2002.
Yeah, that's not saying that that's how they behaved pre-2002. He's saying that's how they certainly should have behaved.
And at page 1325,
325. Which line?
if you look at line 8, the definition of unspecific treatment of minority
This
interest.
is still Mr. Jane.
Yes, I think so. Yes, my lady. That's my, yes, because I'm dealing with the evidence of Pricewaterhouse. As prescribed earlier, for material changes to be made to the NCB profit sharing scheme, the bank should have made the disclosure in a staff circular similar to the manner in which the scheme was introduced.
Well, he's reading out something.
Yes,
This is
he's
not his
reading out
evidence.
something.
What is it he's reading out?
He's reading out paragraph 29, and I'm trying to find what that paragraph is in relation to.
Right, so that seems to be he's reading out Mr. Christie's
Affidavit.
Right, so
I
that's
think it's
not
Mr.
his
Christie's
evidence.
affidavit, paragraph 29.
So that Mr. Christie was giving evidence for the staff association.
Yes.
Right.
Yes.
So this is Mr. Jane reading out
Mr. Christie's statement.
the opposing person's.
Yes, they're opposing accountants.
Yes.
Well, I wouldn't say they're opposing account because, remember, Pricewaterhouse is a witness of fact, essentially, because they are the auditors for the bank.
Yes.
You have KPMG, who is an expert, who agrees with Pricewaterhouse, and then you have Mr. Christie for the staff association, who doesn't agree with either Mr. Jane or KPMG.
Yes, he says as far as he's aware, there wasn't a change.
There was no change.
Well, as far as he's aware, but he's previously told us he doesn't know what was done. So, I mean, you'll need stronger evidence than this to support a submission that the accountants were agreed that throughout PwC had deducted minority interest.
And then I would ask you to look at um, 65 on 218. Middle of the page, did you give NCB an opinion that profit sharing was not triggered in the year 2002? I believe so, because as I said, the records have been destroyed according to the policy. I'm not going to lay my hands on the actual opinion, but I believe that such an opinion was rendered, would have been given, yes. You mean by you personally or by the firm? And he says by the firm. And then if you look at 1, 2,
So I'm afraid that went a little bit too fast for me. So what line on page 1218?
From 9 to 20.
9 to,
from 9 to 20.
thank you very much.
And 1556 at the bottom of the page.
This is still Mr. Jane, is it?
Yes, yes, my lady. Does your firm, I'm at 1556.
So sorry.
I'm at 1556,
Yeah, thank you.
bottom of the page.
Thank you.
Does your firm ever have to deal with the profit sharing between the bank and its employees in any manner or fashion during your period at Pricewaterhouse? We would have annually submitted a calculation using the agreed formula and provided that to the board. That is the extent of our involvement. And then at EF 1, 2, 3.
But if you look at the bottom of 1558, at line 23, again, he's saying that because he hasn't had the records, he can't really say what was done in 1991. He only actually joined the firm in
1991.
Yes.
1991 is significant because that's when Edward Gale came on board.
94, wasn't it 94? 1993. Yes, it doesn't appear in the accounts for 1993, and it does appear in the accounts for 1994.
What does?
Edward Gale.
Yes, 93, 94, yes.
And they do say that there was so at 156 to 157, they submit the calculation annually using the formula.
So where is this?
I just taken it to that bottom of 1556, the top of 1557.
1556.
He would have annually submitted a calculation using the agreed formula and provided that to the board.
Well, he's describing what he expects they would have done.
No, he's saying Pricewaterhouse would have. He was the relationship partner for Pricewaterhouse.
But he doesn't say what the formula, what the calculation would have been. Mm-hmm. He always has to do a formula because he's got to work out the reserve fund. And I mean, the crucial bit is the formula deducting the minority interest.
Yes, but I understood him to be saying that they were doing it in the way that they had always done it from the time that they were.
But you're reading quite a lot into this. As yet, I haven't seen evidence to support your conclusion that they would always have, that there was evidence from Mr. Jane that they always did this. In particular, Lady Rose referred you to the bottom of 1558, where he was asked, could they say they made a deduction of the minority interest in 1991? He says no. He can't say. So it's pretty clear he can't support the assertion that from 1980 onwards this is what was done, or from 1991 onwards for that matter.
I think the highest he can put it is that as an accountant he thinks consolidated profit generally means deducting minority interests, and that was what he assumes they did because of the use of the word consolidated.
His evidence consistently throughout was that the reduction of minority
it's inherent, is
it's fundamental to the process.
Yes, well, one can understand that an accountant would want to balance the two interests in order to make good sense in accounting terms. What we have to consider is whether, when the parties contracted in 1980, whether by taking this phrase, consolidated profits before taxation, whether anyone had in their mind the circumstance of there being subsidiaries with minority interests, because the case against you is a very simple one, that consolidated profits before taxation is a recognised accountancy term which appears in a certain line in a set of accounts before taxation and before the deduction of minority interests, if such interests exist. And that's the nub of this whole case, I think.
But just before I stop doing this and go on to other, can I just invite you to 1231? This is an exchange between the judge at first instance and counsel for the Staff Association during the cross-examination of
page
1231. At line 10 on 1231, the judge is saying to Staff Association's counsel, I'm not sure whether Mr. Jane can assist, because he would be saying, as an accountant, my job is to represent it according to the standards. As to what the bank chooses to do with it, he doesn't have any control over it. All I'm saying is I am an auditor. I understand Mr. Jane to be saying this standard was there before 2002, after 2002, and the very concept of consolidation from the accounting standpoint means you must take account of the minority expression, minority interest, and that taking into account means, for the purpose of proper representation of the accounts, exclusion. So as to after, if the bank chooses to ignore it, then that's the bank's business, but can only say as an accountant, this is my position and this is what my position. So consolidation always means this. You always have to take account of minority interest over statement of account. You mislead investors and so on and so forth. That's why I was asking you what were your arguments on. Because if that is your case, then Mr. Jane can't assist us really much further, because his opinion, I suspect, even if his opinion were produced, all the opinion, just like lawyers, you give your clients advice, but the client don't have to accept it. So all you need to do, witness, I would say, and this is Jane, I would say in this matter, I'm not aware of any time when an opinion was ever rejected. His Lordship, when I say that, the witness, where the management chose to do, I'm not, and the witness is continuing, where the management chose to do something different from what we opined on, I am not aware of that. Because the judge was indicating that, well, Pricewaterhouse can tell the bank what to do, but the bank doesn't necessarily have to follow what Pricewaterhouse tells it to do. But the bank's case always was that it did follow what Pricewaterhouse told it to do. And the witness is saying, I'm not aware of any occasion where we have verified this to the bank and they have not acted in accordance with our advice. And the judge goes on to say, but isn't that your case, Mr. Miller? Isn't that why we are here? Your case in 2002 was the first time since the inception of this profit sharing that the bank is now saying that for the purpose of profit sharing, we are now going to be excluding minority interest. And because of that now, you are now below the 25%. Isn't that your case? So the Staff Association was saying this is something new happening for the first time in 2002. And the Staff Association lawyer is saying, yes, my lord. And the judge says, so your case is independent on whether in previous years the exclusion took it below or the inclusion took it above. Your case is the bank just said, okay, yes, we have figures here. We're not going to take the minority interest for the purpose of deciding whether to pay the employees under the profit share scheme. And if that is your case, that is a matter now between the bank and the association, and who said what, when, and what documentation says. But as far as the account is concerned, his position is, well, that is what you have to do. That meaning the deduction of minority interest is what you have to do. And, my lords, The there was even a point in the transcript where just give me a moment, my lords. The judge appeared to be criticizing the bank for adhering to the formula too strictly. And that would be, I think, at page 1299 to 1300.
Just interested in where the judge's findings of fact are in relation to this evidence. The Court of Appeal summarise it at page 162, paragraph 71. And that is that none of the appellant's witnesses in their evidence testified that the appellant had ever before 2002 deducted minority interest for the purpose of calculating the profit sharing scheme. But I haven't been able to find as yet those factual findings in the judge's judgment.
The judge makes a finding, I think, in his judgment that the bank did not take issue with the statement of Mr. Stewart that it had not happened prior to 2002. And that is actually incorrect, as I point out in my written case, that the bank, in fact, did take issue with the statement that it had not happened before 2002. But I want to emphasize, if I may, that the case was about what happened in 2002. When you look at the fixed date claim form, the case wasn't presented on the basis of what happened before 2000. It was all about whether it was properly triggered in 2002. And the bank was the defendant, not the claimant. And the primary witness, and Mr. Stewart for the bank was on the board of directors of the bank, so he would have had all the audited accounts in his capacity as director and so on.
But just where is his evidence that it had not happened before 2002? Was that in his affidavit or?
If you look at paragraph 59 of my written case, you'll see it says the judge's other conclusion, and I give the reference for that NCB has not said the assertion, naked statement by Mr. Stewart that in previous years the minority interest was not deducted from the line items of consolidated profit before tax is not true, does not reflect the evidence. I go on to say at paragraph 60, the evidence in fact was that not only was there no line item of consolidated profit before tax, but that NCB's witness, Mr. Sadler, in cross-examination by Counsel Brown for the Staff Association, specifically said that he cannot agree with her that the suggestion to him that at no time minority interest was deducted. And the reference for that is in footnote 83 at EF page 1, number 1733. I tried as much as possible, because the evidence is so voluminous, to link it with the footnotes, link all my statements in the written case to the footnotes. I was hoping to show you that the judge had said that, or the judge gave the impression in the course of the trial that the bank had in fact applied the formula too strictly, and I was taking you to 1299, 1300.
Sorry, the page number again, please.
1299.
Yes, thank you.
and I'm starting at line 14, quoting His Lordship. What they are saying is the minority shareholder was always there, so it's not anything new. But it is just that what is new in 2002 is that for the first time they are saying that's what their case is, you know. For the first time, the bank is now going to be insisting in the strict application of the calculation of consolidated profit. And then he says, and that is where, my lord, our pleadings, you will see what is going on, where we said for 16 years this was going on, His Lordship. And that is what remains to be proved, because let me explain something to you now. It seems to me that what you may be thinking, I couldn't go higher than that, is because the phraseology of Mr. Cummings and Mr. Sadler, because when they refer to the year 2002, this is what they did in 2002, meaning they applied the formula. The inference to be drawn is that before 2002, they were doing something else. Now, if that is the way you are reasoning it out, the statements of Mr. Sadler and Mr. Cummings don't say that, you know. They don't talk about what happened in previous years, you know. There is nothing in the statement, as far as I end up reading, that says in previous 15 years, we have never excluded the minority share interest in Edward Gale. They don't say that. What they are saying is that in 2002, we got this advice and we acted on it. So the judge is pointing out to Counsel for the Staff Association that the bank never says that they didn't deduct it in the 16 years prior. And you can't just come and make a naked statement and expect me to act on it. And that's in the court of the transcript. But yet when he comes to give the judgment, he says, in reliance on that naked statement, that this is something that never happened before 2002, and presents it as something that the bank did not challenge. And I have shown you at paragraph 59. And 60. That when the suggestion was put to the bank denied it.
Who is it who's speaking at page 1302? Because is that still the judge?
It is.
Yes, because at line 18 onwards, it seems that that's where he gets to the nub of it, which is, yes, it may be a basic concept in accounting that consolidated profits cut out the minority interest, but that's not what we're dealing with here. We're dealing with what it means in this phrase in clause 2, and that what the bank has done is actually, he says, ignored the minority interest. In other words, put it another way, it treated Edward Gale as if it was 100% owned.
And that is what, going on to the next page, I understand the Staff Association is about. So there was never a deduction of any minority interest, because for the purposes of UC, the bank's conduct was, I am going to treat it as if it is a wholly owned subsidiary. And then come 2002, the bank suddenly decides to become technical and strict. Now they're excluding it. Why are they doing this? So he's suggesting to the Staff Association that should be your case.
It's never been anybody's case that there was some kind of estoppel by convention whereby the parties acted as if the contract meant something different from it meant. Everyone's been working on the assumption. Now it's conceded that this was a term of the contract, and I think you said earlier it's accepted it was as from 1980. Nobody has argued that the meaning of the term somehow changed, or that they could no longer rely on the strict meaning of it because of how they had behaved. So that's also a bit of a rabbit hole.
But there was never any evidence that Edward Gale was ever treated as if it was 100% owned by the
No,
bank in
but
2002.
the question is whether in the clause 2 reference to consolidated profit, Mr. Jane is right to say, well, everybody knows that consolidated profit deducts minority interests, or whether they were using it in a special way that did not, that was actually referring to that line in the accounts from which no tax and no minority interests have been deducted. I think that's where we...
Yes, well, as Mr. Jane said, and I refer to it in paragraph 39 of my report. Well, consolidated really is in the context of a group, right? So in other words, you're saying there's nothing special about it. There is never an arrival at consolidated positions in a profit and loss account without first deducting that. You don't get there unless you go through that portal. That's how Mr. Jane presented evidence. Whether you apply IFRS, IAS, GAAP, whatever.
Well, Mr. Jane's evidence makes perfectly good sense that a proper assessment of the balance of interest between the shareholders of the company, the bank, and the staff would require the deduction of the minority interest. The difficulty, I would suggest, is that the bank back in 1980 chose a certain formula which is a standard line in a company's accounts, namely consolidated profits before tax or group profit before tax, whichever phrase you use, because you work your way down the accounts in a standard way, and you find that figure, which is available not just to the bank, but to all its staff to know where the calculation's been made from.
And those figures were put to Mr. Jane, and he was asked, do you consider that to be the same thing as consolidated profit before tax? And his response was no. And while I'm there, there's an error in this submission I wanted to correct. In the written case of the bank, on page 9,
Yes.
on page 9 of my submissions, which is EF page, the bundle is, it's in tab 3 of the key documents bundle, tab 3, paragraph 29.
So 1839, I think.
Yes.
Yes.
Mr. Jane was extensively cross-examined by Counsel Miller on behalf of the Staff Association. Counsel Miller took him specifically to the line item profit before taxation and extraordinary items and the wrong figure is put in there in error. So I ask you to put a line through 2023285000 and substitute that with 2,209,286. That is the line that was put to Mr. Jane. And he was asked the question, isn't that consolidated profit before tax as in the formula for December 1980? Mr. Jane's answer to that was an unequivocal no, that certainly would not be mine.
Sorry, so just going back to page 449, which is the figure that's being put to him then?
Yes, yes. If you look at 449, the figure that is being put to Mr. Jane in cross-examination is the one that is profit before taxation and extraordinary items, 2,209,286. Before taxation figure, not the after taxation figure, which is what was in my submissions by mistake.
And everybody agrees that that figure does not include any, or that is 100% of all the subsidiaries before the deduction of any minority interest profit.
Yes, because the deduction of minority interest comes below.
Yeah.
Well, I have to warn you, you are now eating into your reply time.
I did promise my friend I would make a correction of something factually inaccurate which she pointed out to me.
Yes.
I would like to do that if I could.
Certainly.
In paragraph 17 of my written submission. My friend showed me a number of court orders made earlier on in the proceedings, which are not part of the record. Well, the court orders, the supporting documents that make it clear that NCB was in fact served with a claim in 2006. So I'd like to correct the statement in paragraph 17 that says it wasn't served with it in 2006. So could I just indicate to you how I would like you to change that paragraph? So, significantly, I'm reading from the top of the paragraph because it explains why NCB's affidavits in answer are post-date October 2014 and why PwC's working papers for 2002 are no longer available by the time of the trial. The fixed date claim form filed by the Staff Association in 2006, could you delete the word never? So it said it should read was served on NCB. And I've asked you to add the words, however, it was a defective document. And I'm going on. The originating document, and will you strike out the words served on NCB? The originating document was, and afterwards, could you add, by order of the court made in 2015, the amended fixed date claim form, which is already there, filed in July 2014. And it is that amended fixed date claim form which the court allowed to stand by its order made in 2015 that was not served on NCB until the 31st of October 2014. That is 12 years after the cause of action first arose on October 1, 2002. And a consequential change, if I may, in paragraph 74, Court of Appeal regarded it as very telling that PwC was unable to say whether minority interest had been deducted at any time in the past in determining whether the PSS was triggered. This statement took no account of the fact that can you cross out the word claim and substitute relevant originating document, was not served on NCB. The relevant originating document was not served on NCB until the 31st of October 2014.
Certainly.
My lords, I know I'm eating. I know I've received the warning, my lords.
You've lost 10 minutes of your reply time.
I've lost 10 minutes of my reply time. I just wish to say then in relation, if I could just move on to the interest point, because that's another point. I gave you the figures as they were some years ago in relation to what is the principal sum and the interest sum, and that's in my written case. So you can you have an idea of what kind of figures are involved here.
Yes, because the commercial rate of interest in Jamaica is so high with your history of high inflation.
Yes.
Even at simple interest, the figures are enormous.
And those figures are in paragraph 19 of the written case, of the appellant's written case. But my simple...
Sorry for interrupting. The judge, at the conclusion of his judgment, left the question of interest over to a separate hearing.
Yes.
And then there were submissions
Yes, my lord.
put in.
Yes.
I can't find those submissions in the PDF.
No, the submissions are not there, but his judgment on the interest is there.
Did those submissions advance a case for different interest rates throughout the whole period from 2002 onwards? So that in the submissions, was the case being made that there should be different interest rates even before judgment was given? Because if so, then wouldn't the opportunity have been to object at that time to any claim being made for interest prior to judgment?
My lord, unfortunately, I am not able to say what submissions were made because I was not counsel then, and there is no record of what the submissions were. So I'm a little bit of a disadvantage in that regard. But what I do want to say is that it is clear that the Court of Appeal, in paragraph 150 of its decision, accepted that the interest was claimed as at the date of judgment, and the date of judgment was 2017, and that, as I understand the law and practice in relation to interest, you can only recover it for the period that you claim. So I'm not disputing the fact that the judge has the power to award it for whatever, that the court has the power to award interest, but they can only do so within the context of what is claimed. When it comes to interest. And in the context of what is claimed, an award covering the period 2002 to 2017 was outside of the period that was claimed. So we are saying that, and the fact, when you look at the Court of Appeal's judgment, you see that they actually set out all the law there and says that that restriction applies to matters begun by fixed date claim form, and then proceeds to uphold the award of interest.
That's on the basis of the claim for further or other relief. They say, well, that's that.
Our submission is that you can't use that to change the legal position that obtains in relation to a claim, because people would then never have any certainty. And it is because I would want to say that, as a matter of common sense, you may be entitled to claim for the entire period, but for reasons litigants may have known to themselves, they may say, well, I choose to elect to claim only for this period. It can be for very many different reasons. And that is why they are bound by their pleadings in relation to, or their claim in relation to interest, because the court would not necessarily know why they have foregone, you know.
Yes, the claim itself in paragraph 10 on page 14 was interest on the judgment sum at the commercial rate at the date of judgment. So what was being asked for was the commercial rate at the date of judgment. It doesn't, as such, state from when the interest was to run.
Yes, and that was a difficulty I had too, which is why I was guided by what the court found. And that is why when you look at paragraph 150 of the judgment of the Court of Appeal, on page 193, you see that the court certainly interpreted it as a respondent having claimed interest at the date of judgment.
Well, I mean, is it your submission that the court was right in that interpretation?
Yes. That is when they're right in that sentence. Yeah. I mean, there's no challenge to that finding, or to that conclusion of the court. That is. I have to sit now. Is there anything? I have to sit now.
Yes.
My lords, unless there's anything I can assist you further with, my lords?
No, thank you very much indeed. Thank you. Ms. Gibson.
please you. The submissions that we're going to make, I'll make the submissions in relation to the core point in the appeal, being the matter concerning the interpretation of the circular and that clause 2. And my learned junior, Mrs. Roberts Brown, will address the court in relation to the matter of interest. Having heard my friend and the questions by the court, I've reconfigured the way I'd start, particularly having regard to how my friend commenced her submissions, where she indicated that members of a group in a wide sense, including staff, can only share in profits belonging to the group. They can't share profits belonging to someone else. That is why the elimination of minority interest is integral to and inherent in the concept of consolidated profits before tax. I believe that is a misunderstanding of the structure of the claimant and how, of the appellant, sorry, and how they see themselves as also the staff association. Because if we look, for example, at paragraph 32 of Houghton Cummings' affidavit, which is at page 221, you will see that, well, perhaps I should start with the affidavit of Mrs. June DeCass, which is at page 210, I'm sorry.
Yeah, her affidavit was only in evidence before the court to the extent that it was accepted by the other side because she wasn't called as a witness.
Indeed, ma'am.
Yes.
And so the point that I'm going to refer to now is a point in respect of which the appellant's witness responded to.
Certainly.
So on that point, which is paragraph 12 of the DeCass affidavit, which is at 210, page 210, she said that when the profit sharing scheme was first implemented, NCB Group Limited was non-existent. However, since 1986, when there was a restructuring of the bank and NCB Group Limited was incorporated and became the holding company and the defendant a subsidiary of same, the profit sharing paid to members of the claimant company has always been calculated in accordance with clause 2 of the terms and general conditions of profit sharing agreement using NCB Group audited financial statements and its consolidated profits before tax at the same rate of 6%. And Mr. Cummings responded to that at paragraph 32, and he says, in response,
Again, the page
page 221.
And this is the affidavit of
Houghton Cummings.
Of Mr. Cummings, yes.
Mr. Cummings, yes.
Thank you.
16th July 2015. So he says there, in response to paragraph 12, 20, and 21 of the DeCass affidavit, I wish the court to bear in mind that on Mrs. DeCass's own acknowledgement, at the time of the implementation of the scheme, there was no group. In the wisdom of the board, the staff has subsequently benefited from the creation of the group. Similarly, as the board expressed the desire to have the scheme endure in the long term, the payment was made subject to the agreement of the auditors. No doubt the board would have been planning for future and possible changes in the law and the financial position of the bank. But the key point that I wanted to take away from this, that it was common ground between the parties that the staff association, the respondent, was intended to share in profits of the group, and so that there was no contemplation of the deduction of minority interest, as my friend is indicating. I agree.
Certainly, it's interesting that the witness, in responding to paragraph 12 of Mr. Cass, doesn't say that Mr. Cass has got paragraph 12 wrong.
Indeed. And so we feel
The fact that what you do is you look to the NCB group audited statements.
yes,
And it's consolidated accounts before tax.
Correct.
You take the figure from the account.
the line
themselves.
item, we say from the line item,
Yes.
by whatever name it is called, consolidated group before tax, profit before tax, and exceptional items, groups pre-tax profits. Those are different labels that were attached to that line item, but obviously throughout you could see that it was accepted that it was the same thing. So we
Who
say
was
that.
accepting?
Could you repeat, my lady?
Who was accepting that it was?
We say, my lady, the parties, and that it was only in 2002 that, so they, although my friend stated that, because her case is not saying that there was no acceptance of a figure on which the profit share could be calculated. What she was saying is that there is no line item in any of the accounts or financial statements of the bank, and she faulted the judge the trial judge, when he said at paragraph 145 that, and paragraph 145 is found at at page 71 of the bundle. The learned judge was criticized for this statement that he made here about having reviewed the evidence and finding that the parties knew what the circular meant when it spoke about consolidated before tax. And it proves that at the time of the circular, the bank quite well knew that the consolidated profit before tax meant, and that is why there was no further refinement. The fact that the financial statements have a specific line item called consolidated profits before tax proves that such concept was known and understood to mean exactly that. So when looking through the financial statements, one could reasonably draw an inference that by whatever name it is called, there was this line item that could be treated as consolidated profits before tax. And what we did, and I don't know if the court will require me to go through all of them, but if we look through all of the financial statements, say that were at least were before the court from 1991 up to 2002, including the director's report, what we will see in those, firstly, is that they are all consolidated accounts. There is indeed a line item, consolidated profits before tax. And when we get to the notes to those financial statements, it explains as a significant accounting policy what consolidation means. And it speaks to the fact that it is taking into a pool, as it were, all of the profits from the parent, the subsidiaries, and the associated companies. And then further down, it made kind of like an exception in relation to the associated companies, and it said that they were to be treated on the basis of equity. And so clearly, the profits of the associated company, it was obvious at the outset that that would be deducted. That's the whole.
Where do we see that?
Yes.
Well, you will take us through these. But
yes, I'm going to.
It seems to be agreed that the accounts were prepared in accordance with the recommendations of the Jamaican GAAP.
JSSAP.
The General Accepted Accounting Practices.
Jamaica Standard.
The Jamaican Standards,
Right, yes.
which I think is referred to in the documents as Jamaican GAAP.
Yes, my lord.
And unfortunately, we haven't got in front of us what the Jamaican gap said, but there was evidence, I think, certainly from the appellant's witness, Mr. Jane, that there was compliance with Jamaican gap.
And from all of the witnesses in terms of the Jamaican gap, and in fact, throughout from 1991, from 1980 up to 2002, the accounts with which we are concerned, it was common ground that the whole concept of minority interest didn't change. It was always something that was known to be included as part of consolidated accounts.
Yes.
So that, yes.
But and your point, I think, is making it more pointedly, is that the accounts show that in the statement of the group profit before tax,
Yes.
that figure included the whole profit of the subsidiary, in which there was only a majority, not 100% interest.
Indeed, yes.
Yes, but you can take us through these accounts. That would be helpful.
Privy doesn't, sir. If we start as at 768, I think we are a page out, so it would be 769 for you with the 1991.
So what page number, sorry?
Page 768, which I think is 769 for you on the electronic bundle, and it says consolidated profit and loss account, year ended 30 September 1991.
Yeah.
And so if we go down, we will see that there's a line item profit before taxation being 232,648 for 1991. And just by the title, we know it's consolidated accounts, but when you go over leaf to page 772, where it talks about the notes to financial statements, significant accounting policies.
Yes, I think we're 771. I think we're one.
771.
I think we're one page out in every case.
I see.
Yes. So
It's with the
yes,
771.
consolidation. Yes.
Where it says, and it explains what consolidation is. It says, all amounts in these financial statements are stated in Jamaican dollars. The consolidated financial statement represents the results and the financial position of the company and its wholly owned subsidiaries and partly owned subsidiaries and associated companies, except to the extent explained more in 1B. So that is the base on which I was indicating that the consolidated profits before tax would include the amounts for the subsidiaries, and that there's an exception in relation to the associated companies. So one would expect to see, and in fact you can see on page 768, that there is at the outset a deduction in relation to the associated companies. Somewhat out of sequence.
Is that what's meant by the equity method? Yes.
Could you repeat, my lady?
That's what's meant by the equity
Indeed.
method.
Yes, ma'am.
So where in 767 do we see the minority interest in results of subsidiaries? That's the reference.
That's after taxation.
Yes, after taxation. And in that case, were they treating, they had one subsidiary then, NCB Insurance Services, in which they had 74% stake, and then they had two associates.
So there'd be a minority interest.
So that 2475 at page 767 is then deducted from the 161726 to get to the 159.
We want to get to the 1515. No, the 2475 is deducted
Yes.
in order to get to
From the profit after taxation.
Yes.
Yes.
Yes, and we see the associated companies treated before profit,
Correct.
before taxation.
Yes.
Yes. And your position, as I understand it, is in these accounts, when you talk about consolidated profit before taxation, you're talking about the line that is there.
Correct.
Which in that case is 2327648.
Indeed.
Would that be a convenient place for us to adjourn?
Why is the 1413 share of results of associated companies, why is that a deduction in brackets rather than...
Because of it states, I think, at 1B that it's accounted for on the equity method. So I'm not good at accounting, but it does appear to me that it would mean that they would have taken, well, it says by this method, the group's share of profits and losses is included in the group profit and loss account.
Yes, I understand what they're doing, but you would expect there to see a positive amount, which is the equity proportion of the profits of the associated companies, but that doesn't seem to be.
Unless what they've done is
Unless they made a loss.
included it at the top, or
They may
they may have made a loss, I suppose, yes.
Loss.
Yes. Is this a convenient point
Indeed,
to adjourn?
indeed.
Thank you very much.